Hey, everybody. Welcome to the Social Media and Politics podcast, bringing you expert insights into how social media is changing the political game. I'm your host, Michael Becerra, Associate Professor of Communication at Lund University. Remember, you can follow the show on X at SMNP Podcast or visit us on the web at socialmediaandpolitics.org. All right, y'all. Thanks so much for tuning in. After a bit of a summer break and getting things started with the new academic semester, it's time to get back to some podcasting. And even though it's been a while since the last podcast, I thought we'd keep on this topic of the Digital Services Act and its rollout and implementation. So the topic of today's episode is going to be on out-of-court dispute settlement bodies. So these are established according to the DSA, as an extrajudicial way for users to dispute content moderation decisions by social media platforms. So if your account's been blocked and you want it put back, or you want something taken down and the platform has refused, you can either take the platform to national court, and who has the time and money to do that, or you can go to an accredited out-of-court dispute settlement body. And my guest today is Thomas Hughes. He is the CEO of Appeals Center Europe, which is one of these out-of-court dispute settlement bodies. And they've just released their first transparency report, which highlights the amount of disputes they've had by various platforms, the amount of time it's taken to process them, what type of content are in those disputes. And there'll be a link down in the episode description where you can read country-by-country breakdowns, the Appeals Center Europe's experience with different platforms in terms of delivering content, which is something that we'll talk about in the episode. But overall, I think this is a really interesting look at not only one of the DSA's initiatives, but also in this early period where these out-of-court dispute settlement bodies are being rolled out. This is one of the first glimpses that we have into how this process is actually going. So, for example, if you look at the report, you'll see that the number of disputes has really spiked in that second half of the year as more and more users come to understand that these entities actually exist, which is also a challenge of how do you communicate that these out-of-court dispute settlement bodies are available to users is something we'll also talk about in this episode. And we'll also broach the topic of the various initiatives for users to dispute content moderation decisions. I mean, there's obviously national courts. There's Meta's Oversight Board, where Thomas was previously the director of the Oversight Board administration, so he's well knowledgeable of the landscape. But there's also these various actors popping up in the form of out-of-court dispute settlement bodies. And so kind of where is this all going? What does it mean? And how has the process gone in the past year is what we'll cover in the episode. So without further ado, let me turn it over to Thomas Hughes. Again, he is the CEO of Appeals Center Europe. Thomas, thanks so much for taking the time out, and welcome to the Social Media and Politics podcast.
Michael, thank you for the invitation to join you.
So to start out here, could you give us a brief introduction into out-of-court dispute settlement bodies? What are they and why were they established?
So out-of-court dispute settlement bodies are part of the Digital Services Act framework. I think for any aficionado of the DSA, they'll understand that there are certain components of the legislation that are more sort of internally facing requirements upon the social media or very large online platforms and smaller platforms as well, of course. Things like, notice and action or internal appeal mechanisms or transparency reporting. And then there's sort of the more what I think of as the sort of framework components that have external bodies built within them. And of course, part of the beauty, if I can use that word, part of the beauty of the DSA is the fact that it creates this ecosystem of interlocking actors, but also that it pushes out to independent parties some of the functions that you might sort of otherwise think would fall under the statutory regulator. And there's a good reason for that, because in terms of free speech and other rights, we're dealing with those fundamental rights, and it's not always appropriate that the state should take a direct handle or control over deciding what is appropriate speech and what is not, outside of the realm of what is illegal speech, of course. So in that framework where you've got those, as I described it, external actors, you've got sort of the auditors for systemic risks, you've got vetted researchers, you've got trusted flaggers, and then you've also got out-of-court dispute settlement bodies. Now, I think those institutions are particularly important because actually they are the element of the framework of the DSA that really connects with individuals and really gives people the opportunity, I think, to take more control over their online lives and environments and over their social media ecosystems, but gives them a direct and let's say realistic path to be able to challenge the decisions that these platforms are taking about content that they themselves, those individuals, are posting online and have been taken down by those platforms, or content that they see that remains online that they believe is harmful and potentially violating of those policies or potentially the law. So in that sense, it really empowers those individuals in a way that the digital ecosystem just hasn't in the past. If you were, the average citizen, the idea that you would, take a social media platform to court would be an incredibly time-consuming process. You need a lot of legal knowledge, and it would be very expensive. This essentially is a free, hopefully much faster moving, hopefully much more simple way that allows those individuals, as I say, to challenge decisions that affect them in a very meaningful way. I think we all now clearly understand that things that play out online and decisions that are taken about content and rights online have a very, very real impact offline.
Right. And let's talk specifically about your organization, Appeal Center Europe, which was established last year as an out-of-court dispute settlement body to swiftly and impartially process content moderation disputes. So could you tell us about the organization? And in particular, you mentioned this kind of network of interlocking actors. Like, how does your work differ from the work being done by Meta's oversight board, for example?
Yeah, good question. So the Appeal Center Europe, we are amongst the first out-of-court dispute settlement bodies to have been created. We are not the only one. There's a half a dozen now, which is very welcome because you want an environment where you have a plurality of actors. I think not a deluge of actors, because then it will become unimplementable. But certainly in the same way that you want multiple actors functioning across the social media landscape, you want multiple actors then engaged in out-of-court dispute settlement as well. We are a pan-European actor, so we cover all of the EU states. We function in 6, soon to be 7 procedural languages, although we can handle content in almost all languages spoken within the EU. And our focus is on policy violating content. So we don't handle illegal content, but as you can understand, illegal content is quite often policy violating at the same time. So we are certified to cover all of the platforms that are designated as VLOPs by the European Commission. And we started off with the largest. So we started with Facebook, YouTube, and TikTok. And during the course of this year, we have subsequently also taken on Instagram and Threads and Pinterest as well. And we will continue to bring on board other platforms as we move forward. Now, I should allow, of course, the Oversight Board to speak for itself. I'm not a representative of the Oversight Board. I just want to make that very clear. But of course, the Oversight Board takes emblematic cases, takes very few cases, but the really emblematic, impactful, important cases that play out on Meta's platforms, so on Facebook and Instagram and Threads, and it issues back to Meta decisions that are binding. The Oversight Board, of course, is a independent self-regulatory body that was established by Meta in 2020, and the types of decisions that it takes, they're very well considered, right? They're very in-depth, they're very analytical. I would argue that they sort of set precedent that other platforms may want to think about, but certainly Meta as a company would almost certainly be thinking about as it develops its own policy. The Appeal Center Europe is a cross-platform, so obviously we deal with multiple different platforms. The decisions are non-binding, but we then have a co-regulatory structure, so we are underpinned statutorily, although we are ourselves an independent company. So we are not part of the statutory framework of Ireland, where we are established as a company.
Right. And I'm curious, you mentioned that there's about a half dozen of these out-of-court dispute settlement bodies. And I'm wondering, like, what differentiates them? Like why do we need multiple ones? Will they have different profiles, or kind of how do you see that landscape evolving?
Yes, they have different profiles. They have different sort of genesis as well. So some are specific to platforms, some are specific to languages or specific to countries. Some deal with other types of VLOPs. So, of course, the family of VLOPs is not only social media. You've got e-commerce and marketplaces and adult sites and so on and so forth. So other of the ODS bodies deal with other types of social media. And in terms of where these entities have sort of sprung from, some like ourselves, like the Appeal Center Europe, are purpose-built. So we are a company established solely for the undertaking of out-of-court dispute settlement. Our governance structure, we have luminaries on our board. I'm very pleased to say, former Supreme Court judges, former heads of national regulators. But our sole purpose as a mission-driven, not-for-profit company is just to do out-of-court dispute settlement. You've got others who, and again, I should let them speak for themselves, but you've got others who are also performing ADR functions or who have connections to different types of backgrounds, all of which are very welcome and legitimate. And then you've got even others. I think in Austria, the body was originally set up by state actors. So again, there's different evolutions for different bodies in different countries.
Interesting. Yeah. And I'm curious, I couldn't think of a better way to kind of phrase this question, but I was wondering about what is the source of authority for the decisions that are made by out-of-court dispute settlement bodies? Like in a traditional court, a judge or jury has a kind of legal mandate to render a binding decision, but here the decisions are non-binding and made by experts. And you sort of mentioned that they're former Supreme Court justices or legal experts, but what is the source of their authority in this kind of, untraditional extrajudicial practice, if you see where I'm going?
Yeah, sure. I should note that the types of backgrounds I mentioned earlier, that is of non-executive directors on the appeal center. So they are not decision makers in specific cases. They are responsible for the governance of the institution. But in terms of the authority, so the authority for the institution per se itself, of course, is derived through the certification that it receives from the digital services coordinator. For us, it's obviously the digital services coordinator in Ireland, which is the Commission Naman. And that body, by law, through the EU Digital Services Act, has the authority and power to certify entities to undertake out-of-court dispute settlement. In terms of the framework and the standards that we apply, of course, we are applying policy. So we are looking at the platform's policies, which are part of their terms and conditions, which is part of their agreement that they've set up with users as they engage with individuals and users. And we look at those policies and we interpret them as we think they should be applied. But as I say, based on the written policy of the company, with consideration for elements of policy, like particularly exceptions or principles or values that the company also has as part of its stated policy, and also with consideration for if the company has made a commitment to human rights standards as well. So the framework and the values through which, or the tests and the values through which the policy is applied could be multifaceted. But at its heart, it's about the application of the platform's own policies.
Right. And I had a question just about that, because I know it's very tricky territory with balancing voice and safety and these type of things. But on your website, it mentions that experts' decisions are made by the Appeals Center normative framework that you apply to these cases. And I found that kind of interesting because there could arguably be a conflict between impartial rulings and a normative framework. Usually we think of impartiality and normative values as kind of potentially in conflict with one another. So how do you balance impartiality and normativity when you're approaching a case?
Yes. I mean, we don't think that does jeopardize our impartiality. And the reason for that is that the framework itself, as I mentioned, is built upon the platform's own policies, which form part of their own terms and conditions with their users, but then also through the prism of fundamental rights and rights standards and tests that exist in the application of those standards. And of course, those themselves, feed back to, well, we don't apply national law, right? But they feed back to sort of constitutional and legal frameworks as well. So to the degree that you could argue that, human rights and rights standards and policy is unto itself sort of value-based and normative, then yes, you are correct. But I think it gives us a pretty firm framework upon which to make decisions.
Gotcha. And I want to get to some of the findings from your transparency report in just a second, but could you walk us through the process of reviewing a case and rendering a decision in kind of broad strokes? I mean, I'm sure there's a lot of variation in the types of disputes that you get, but what does that kind of case handling and processing usually entail step by step?
Yeah, of course. So the way the process works is that a user should first make an appeal, an internal appeal to the platform, either to have a piece of content restored or to have a piece of content removed, or to have an account that's suspended, to have that restored. And then if the platform comes back with a negative response or doesn't come back with a timely response to that, the user can then submit a dispute to us. That dispute, sort of technically speaking, would be submitted via our portal, so appealcentre.eu, and we would then receive that through our stack in our system. We would then go to the platform and make a request to receive the original content and provide certain data fields that will help the platform locate that content in their system. The platform will then respond with that content, hopefully. Obviously, as we go into some of the details of our transparency report, I'm sure you'll have questions in regards to that, but the platform will respond with the content in question. We then have layers of escalation and also different types of specialization in our case ops team when we review individual cases. So to your point, how a case is then routed would very much depend on what the subject matter is of the case, what the language, what the country context, what the policy in question is. But there are layers of escalation within that where you may have multiple specialists looking at a particular case, and then even escalating up to what we call a rights review if it's a very emblematic case. Once a decision has been made on that case, and that could involve us going back to the platform or the user and asking for additional information, we will then issue a decision, and that decision is provided both to the platform and the user at the same time and is available in the portal. At the moment, it rests with the platform then to decide whether to implement the case and to inform the user about that. But we are asking platforms to also inform us so we can inform users about the outcome of cases and also to complete, as it were, the data set to be able to see from start to finish what things look like in terms of decision-making and implementation.
So it seems like there's quite close collaboration with the platforms during this process. And yes, we'll definitely come back to that later on. But I'm curious, who are you in contact with at the platforms? Do they have certain staff or teams that are developed specifically to liaise with out-of-court dispute settlement bodies? Is that something that the DSA sort of mandates, or does it differ by platform? How does that kind of contact between the platform work?
Yeah, I think the DSA mandates that points of contact need to be established. I don't think it prescribes exactly how that should be structured within the platforms themselves. But to your point, all the platforms we engage with have teams that, at least to my understanding, I mean, we've not asked them to confirm this in any way, but to my understanding are there to engage with out-of-court dispute settlement bodies. And those teams, again, we've not asked for detailed responses on this from the platforms. But again, my understanding is that, those teams are sort of comprised of members of their legal teams and their public policy teams and their trust and safety and product, and that those teams kind of collaborate together to both, do things like make sure that the technical systems are working, because obviously there's a data exchange piece that goes on, or that the legal terms are agreed and in place, or that cases can be found, or that where there is challenges or issues around a case, that they can analyze those correctly.
Yeah, it's interesting. So they're kind of pulling from all different types of expertise within the company, it seems.
Yeah, I think that's a fair statement. But again, I have to caveat all of that by saying you should ask the platforms, because I don't know that for a fact. That's what it looks like from the outside. Let me put it that way.
Right. I was just curious. But so let's dive into some of the findings from the Appeal Center Europe's first transparency report, which users can check out in the episode description. And this is kind of a report of your experience over the past year, where you received 10,000 or more disputes within the EU, covering Facebook, Instagram, TikTok, and YouTube. And I know Pinterest is on the way. But what I want to ask first about is that only 1/3 of these 10,000 plus disputes fell within your scope. So you mentioned that you don't deal with illegal content, but could you outline what that scope is? So when is a dispute kind of in versus out of the scope of disputes that you handle?
Yeah, so as you say, we've received since towards the end of last year, but as the report says, obviously it's increased month on month, but we've received these 10,000, of which a third are within our currently eligible scope, but not within necessarily our full certified scope. So what I mean by that is that we obviously launched with certain platforms and certain types of content and scope, but we are certified to cover more than that. And we are working very actively to try and, continue to make sure that we are fulfilling our full certified scope. But as you can appreciate, each thing that we do additionally requires some new tech build. It requires new policies to be analyzed. It requires engagement with platforms. And again, I'm very happy to go into that in a little bit more depth and explain, why we need to sequence that work out as we move forward. So looking at the scale of cases that are eligible as compared to ineligible, and again, just as a sort of a comparative marker, By coincidence, recently I was talking to someone who works in the advertising standards realm, and I relayed this fact that we had a third of eligible cases, and their response was very positive. Their response was, "Oh, well, when you talk about advertising standards and people submitting complaints about advertising, actually the number of eligible complaints sort of goes down to very, very low numbers in terms of percentages." So that's, from their appreciation, was a good number. But that said, obviously our goal is to bring that up as much as we possibly can. Disputes that might not be eligible, they could be incomplete. So they are lacking key pieces of information to be able to process the dispute and to be able to pass the dispute on and to request the information required. Or we cover policy, but there are certain types of issues that we don't deal with, either because we feel that they are really too egregious for us to be handling. So things like CSAM, and actually seems to be quite a significant number of account suspensions for CSAM.
And what exactly is CSAM, if you don't mind me butting in?
Child sexual exploitation material. Yeah, I mean, you would assume that if someone is appealing an account suspension for CSAM, you would assume that they really believe themselves that that is not the reason, or that they have not done anything to violate that policy. But nevertheless, that is one area as an example. But also, things like coordinated inauthentic behavior, for instance. So actions like that, we are unable to ingest the very complex data and signal that is required to really do sort of broad analysis across multiple accounts to establish whether someone's account has been taken down for issues like that. So we are trying to, or moving towards trying to take in more areas like fraud and scam and hopefully impersonation and so on, because these are issues that affect an awful lot of people and they lose access to their accounts. Obviously, they feel unjustly on the basis of some of these policy areas. But at the moment, unfortunately for us, we don't handle them. So that gives you a sort of a flavor of some of the types of cases that would be ineligible.
Gotcha. So you've already processed about 1,500 cases. And of these 1,500 cases, you've sided with the user 77% of the time. And there's a key caveat here in that 2/3 of those decisions were defaulted to the user's favor because the platforms did not provide you or were unable to provide you with the content to help with that dispute. So could you describe more or less kind of what's going on there? I mean, are platforms like Facebook, Instagram, TikTok, and YouTube like losing track of these posts, or are they refusing to comply, or kind of what's the reason that they're unable to deliver this content to you?
Yeah, again, the picture is mixed, and you've outlined kind of the key two categories of why. So quite often the platform is unable to locate the content, and really you would have to ask the platforms for a detailed technical sort of description or analysis as to why they are unable to locate certain types of content. Account suspensions are particularly prevalent in that area. And again, this is assumptions on my part rather than any fact, but assumptions as to why that is difficult to locate may be that they haven't built pathways and systems to be able to handle necessarily internal disputes in those areas. So therefore, they can't readily access that kind of information, at least through the tools that they are using to handle out-of-court dispute settlement. And then the other pot would be where the platform refuses to give us the content in question because they deem that the particular dispute is out of scope for us. We are very precise, as the ineligible to eligible stat that you quoted earlier shows. We are very precise in what we send onto the platform. We do an initial triage. It's not just a pipeline through which anything that comes to us moves through to the platform. We can have established in advance with the platforms what data needs to be provided, what signal is required for them to be able to process a dispute, and agreed with them, right? We don't just take it on their guidance, right? We establish that ourselves. But we make sure before we send a dispute that it fulfills all those criteria. But again, there are areas where the platform may say, well, we don't think that this particular issue should be in scope, and we're not going to provide you with the content. Or there could be scenarios, as are called out, like with YouTube, where they just have refused to give us content at all, and we have been talking to them for a year, trying to get the sort of the right data protection agreements in place and so on and so forth. But those conversations have just dragged out indefinitely. So these are the types of issues that we still hope to resolve with the platforms. But of course, in the end of the day, it might require the regulator to instruct them.
Yeah, I was going to ask you about that because in the report it's quite clear that YouTube seems to be a little bit more of the hassle here, particularly with challenging the scope of your remit. And I was wondering, like, yeah, what's the recourse for that? It seems like the DSA is quite clear in what it mandates. So is this something that you have to go back to the regulators to? Is this going to be a sort of protracted court issue that compounds the implementation of the DSA, or how do you see that moving forward?
My sincere hope, in going into all of this, we go in good faith, wanting to have dialogue with the platforms, wanting to resolve issues. We have found that to be perfectly possible with Pinterest and Meta and TikTok. So I would hope that it is also likewise possible with YouTube. But of course, the road can only be so long, right? And we do need to find resolution to this. And I wouldn't say that with YouTube necessarily it's about our scope. It's really about their interpretation of Article 21 and out of court dispute settlement, which I have to candidly describe as being really quite limited and restrictive. So I still hope that through dialogue, right, we will get to a place where, the percentage number of decisions that we can issue on YouTube cases, which currently sits around something like 10%. It's very low where we've managed to issue decisions that can improve. And I would like to believe the case can be made to the platforms as well, still, that this is really in their interest, not just from a strict compliance perspective, but because out-of-court dispute settlement helps create a fairer, more equitable, more transparent online environment. I realize platforms, have to accept and cede that they have these bodies now that are going to issue non-binding decisions to them, and they're going to have to review those and take those into consideration and explain, maybe at an aggregate level upstream to the regulator when they don't implement certain types of decisions, why that is the case. But that makes for a very healthy environment, and that makes for an environment in which users will feel safer and hopefully be more engaged online. And many of the worse issues that we see playing out on social media, hopefully, I don't assume those issues are going to be solely mitigated through out-of-court dispute settlement, but, out-of-court dispute settlement together with systemic risks, together with vetted researchers, together with trusted flaggers, like all of this ecosystem, if it works together, if it locks together, if the cogs kind of connect, will help the platforms and it will help users and it will give us a more healthy online environment. So, I would like to hope that the platforms do see the bigger picture here.
Yeah, and I think it's also about whether users see the bigger picture. I totally buy the argument that it's in the platform's interest that their users know that there are these out-of-court dispute settlement bodies, but that requires that the users actually know about them, which gets into the idea of signposting. So just to provide the listeners with a bit as we're talking about platforms. So the bulk of disputes that you've processed have come from Facebook, that's at 55%, followed by Instagram at 18%, TikTok at 17%, and YouTube, as you said, at 10%. But again, it really requires that users know about this opportunity that they have provided by the DSA. And that's something you discuss at length in the report as the concept of signposting. So could you explain what signposting is and how do the different platforms fare in practicing it?
Yeah, so signposting is the term that we use to describe essentially the information that platforms provide to their users about out-of-court dispute settlement and how they can access it and utilize this service, access their rights in that sense. The law requires that this be clear and accessible, and I think a very reasonable interpretation of the law, in fact, and some of this is clearly written in the law, requires that it should be in the statement of reasons that the platform provides the user, requires that it should really be part of the internal complaint mechanism. So we argue should appear at the end of that mechanism so that the user is clearly instructed, that they can access out-of-court dispute settlement. And there should be a web page, we argue, that is dedicated to out-of-court dispute settlement that's easily findable on the platform's site. And all of that should be done with the avoidance of dark patterns, which are also spelt out in the legislation. So what I mean by that is, as we unfortunately see for one of the pathways with TikTok, it should not be that this is available, but it's a dark gray text on a light gray background in a very small font, right? That is not easily findable. I think that's not hard to understand that's visually difficult for a user to identify. Now, different platforms have sort of lent into this in different ways. I'm sure they would all argue that they are compliant with the law. I would possibly dispute that. And some, like with YouTube, actually, there are areas like the internal pathway, as you can see in the report, that we just don't know, right? We've asked for clarification. We're just not told. We just don't know what they are or aren't providing. To the point that you made earlier about the number. Now, of course, the percentage and the number of disputes that we're receiving each platform is different. It has different policies. That is perfectly permissible, right? And is welcome. And so, has different types of content playing out on those platforms that are harmful in different types of ways. So I would not expect to look at all platforms and say, well, you must all equally have the same amount of different types of potentially harmful content, whether that be, self-harm or, hate speech or bullying and harassment or regulated goods or misinformation, right? Of course, it's going to vary by platform. But you have a situation in which the platform with the most monthly active users, that's YouTube, I think it's 400 million plus now. So clearly the largest from that perspective has only 10%. And then you've got a platform like Facebook, arguably the second largest, right? But notably smaller, has 55%. Now, we would argue very strongly that although there will be some variance between those platforms because they are not identical, and I do not suggest that they are, but that is not an equal equation between the two. And we think that signposting, so the information provided to users about their right to appeal to ODS, is one of the key factors that drives users to be able to utilize that right and therefore drives dispute numbers.
Yeah, that's interesting. I'm just kind of thinking out loud here, but I do wonder, YouTube is a little bit different from Facebook in the sense that it's video content, it's longer form. Maybe that's more technically challenging to identify some of these things. But it's also not based on user to user interaction so much, right? It kind of has this creator to subscriber type of design. And so I wonder, when you're thinking about things like hate speech, like it's one thing to find an instance of that in a 45-minute YouTube video versus like a direct, I'm commenting a hate speech type of comment to your post. So I do wonder if I totally agree that it's low, but I wonder if there's also technical challenges, but also the way the platforms are designed that are going to affect what users decide to report.
Yeah, no, look, that's a perfectly fair point. And as I said, we do not assume that either the type of content, the nature of the platforms, the policies that are applied, like creates a sort of a, for want of a better description, a level playing field, or it's equal between all platforms. But when you look at a platform like YouTube with its long form video, where you can equally have within a long video, right, violation, but also you have comments underneath those videos, which can be more interactive in their nature. The two things just really don't stack up. But what we do see from our side is this pretty poor engagement from YouTube and low numbers, right? And we just think there's an equation between those two things.
No, absolutely. I kind of blanked out on YouTube comments. Those can be pretty nasty. But let's turn to the actual content that users are disputing, which overwhelmingly, according to the report, is hate speech, which was 38%, followed by nudity at 13% and bullying and harassment at 9%. What I kind of found interesting is that misinformation, which is this huge kind of concern, especially with the EU right now, was quite low at 4% of disputed cases. So what do you think explains the huge prominence of reporting hate speech over all other types of content categories?
Yeah, probably what I would say first in relation to that is that the Appeal Centre Europe, as an out-of-court dispute settlement body, our goal is to share data as frequently and abundantly, as the law and our processes allow. So we don't see ourselves necessarily interpreting that data or doing research or advocacy around that data. We would like other parties to do that, and that's why we want to make that data available. That said, there's been a lot of reporting from civil society and media and other actors that sort of say, well, there has been an increase in hate speech and hateful conduct related content. So that could be part of the reason why we see so much of that coming to our attention. We also see some organizations are starting to learn about out-of-court dispute settlement, and some of those organizations, I think, are probably more focused on that type of content. And then I think the third thing I would point to is that the platform policies themselves, as they relate to misinformation, are actually, I think, more narrow than many people appreciate. So for misinformation to be policy violating, it often has to be connected to sort of health-related misinformation where there is an obvious imminent harm, or to conflict, or to election and election processes, or democratic processes. So that does narrow down the scope a lot. But with all of that said, I do agree that the point that you make is an interesting one. I wouldn't have expected hate speech to be as large as it is, and I wouldn't have expected misinformation to be comparatively that much smaller.
Yeah. So just a couple last questions for you here. One, a very kind of technical one, and then one, a big kind of broad societal one. But getting to the technical part first, To what extent is when you receive a dispute, I could imagine automated systems, they just go out and flag things. Like, let's say they flag a nipple as nudity. And then when a human looks at it, they see it's in the context of breastfeeding or, breast cancer awareness or something like that. And then it becomes much more complicated. So I'm just curious, like, are you receiving a lot of disputes that are just kind of miscategorized by an algorithm and are very easy to correct? Or are the bulk of the disputes really these sort of tricky social context questions of, is this hate speech or is this sort of protected speech?
Yeah, no, I think the sort of misclassification point, is a significant one. I wouldn't necessarily point only to algorithmic misclassification. I think human misclassification probably plays an equal, maybe even greater, right? But an equal part. I can't comment on that accurately because we don't necessarily see what the decision-making process that has taken place internal to the platform. So it's not necessarily apparent to us whether this has received escalation, has had human review, was only being looked at through automation and so on and so forth. But certainly, errors, mistakes quite often find their way to us. And then the other one is context. Context is king when it comes to decision making. And I think quite often many of these platforms are trying to move at speed. And when we review content and cases, we're just moving, a lot more deliberatively, a lot slower. So we're taking more time to assess the case, to look at the context, to try and do the relevant research and so on and so forth. So yeah, again, I think just getting the context right and understanding it plays an important part.
Absolutely, and it can be super difficult. So my last question for you has to deal with the scale of these decisions. And I don't want to sound critical, but just looking at the sort of raw numbers here, if we look at Meta, where Facebook and Instagram represented over 3/4 of these 1,500 disputes, Meta actually implemented your overturned decision about 100 times. And so if we think about 100 posts in a year relative to all the traffic on Meta platforms, it's not a huge number. So how do you see the broader implications of out-of-court dispute settlement bodies? I mean, is the idea that by having these overturned decisions, it may lead to community guideline changes that would scale across the entire platform? Or is it that, even if it's only a small number of posts that are overturned, then that's still sort of exercising the civic rights of the user. So how do you see that trade-off, I guess, between what the platforms actually implement and the amount of work that's going into these out-of-court dispute settlements?
Yeah. So I think that number is a little misleading insofar as what we are seeing at the moment is that the implementation rate for our decisions is around about 50%. And let me come back to that because you could equally say, well, only 50%? You're like, and I'm very happy to explain why I actually think the 50% of cases that are not implemented could be even more impactful and important as the 50% that are. So the 100 figure, if you think of it as a sort of sorry, this is a horrible analogy, but it's a conveyor belt, right? And each case is a product on the conveyor belt. The ones that are at the far end of completion, because we're only really kind of half a year into our process, they're only just starting to hit the end of the conveyor belt and be boxed and finished and completed. And that last piece has added complexity because within the legislation, it's not required that the platform build systems and come back to us and inform us about implementation rates. So the data in the report is just where we have been told this, but it does not necessarily reflect how many have been implemented. And it does not reflect, hopefully in the future, us being able to say more consistently, no, like we can see that this 50% rate equates into this many decisions. But if that 50-50 number holds, right, then obviously the number that you quoted is going to be, even for the 1,500 cases, is going to be much higher. It's going to be much higher for the 3,300 and so on and so forth, as each of those cases reaches the end of that conveyor belt. So I would say, please ask me that same question in 6 months, and we'll have a much better idea what it looks like. The point around decisions that are implemented compared to decisions that are not. So there's a tie back between Article 21 and out-of-court dispute settlement and Article 35 and systemic risk. And that tie back says that out-of-court dispute settlement case decisions should be taken into consideration when the auditor looks at systemic risk issues and then passes those reports to the regulator to assess. So I can imagine a world in which this won't be done by the appeal center because it's not our role, but I can imagine a world in which the auditor and or other actors, civil society, media, whoever else, might be saying, well, wait a second, look at these decisions here. Like we've got 1,000 decisions here. that clearly show that this particular community in this particular language, maybe in this particular city, was targeted with this particular slur word or this particular emoji or around this particular sports event or whatever it is. And the out-of-court dispute settlement body said repeatedly, this is hate speech, right? And this is harmful, and this needs to be taken down. And the platform repeatedly said, no, we disagree. It's not hate speech. We're going to leave it up. So I could imagine a world in which that is flagged through the systemic risk process. And then the auditor then flags, well, wait a second, there's a reoccurring risk here that the platform has not mitigated. And then the regulator comes along and says, platform, you need to mitigate this risk, right? We agree that this is a risk and you need to do something about it. And if the platform then refuses again, then again, this is way beyond Article 21, but then you're into enforcement action and all that sort of world as well. So this is one of the ways in which I think you get back to this original kind of beauty of the DSA. In all its complexity, there's beauty in there, right? So it's one of those interlocking cogs where you can see how out-of-court dispute settlement connects to systemic risk. Systemic risk obviously would connect to policy and product change at a systemic level within the platforms. That would then obviously then reconnect with the types of decisions that you would see coming back and being disputed to out-of-court dispute settlement. So in a perfect world, I'm sure this is many years away, but in a perfect world, you could imagine then coming back to the ODS decision data and saying, okay, we can use that actually to measure whether that risk was properly mitigated and whether that process, that particular slur word in that particular city in that particular language, whether that is reoccurring. So again, it'll be very interesting to see how all of these things fit together over time. But there's clearly the opportunity there to sort of maximize impact by making those links.
Interesting. So just to try to summarize, what you're saying is that even if the platforms don't implement the decision, there's still this kind of trail of transparency or potential accountability if something happens in terms of systemic risk later down the line.
Yes. And it won't be that the regulator or the auditor looks at individual decisions, right? I do not expect, and I don't think it's necessary that they would sort of say, well, let's look at every single individual decision you didn't implement. But I do think it will happen where there is clearly blocks of decisions where the platform and the ODS are disagreeing with each other. And it won't be for the ODS to decide whether that is a systemic risk, to be very clear. That will be up to the auditor to flag. And my understanding of the way some of the auditors are working at the moment, even they would not interpret whether that is or isn't a risk. I think they would flag it, categorize it, measure it with whatever system they have in play at that time. And then the regulator will look at that and say, well, is that a risk or is that a risk?
Absolutely. I mean, and I think one of the really cool things about this transparency report is it's exciting to see the rollout of these out-of-court dispute settlement bodies, and it gives us a glimpse into what hopefully will be much more of a standard practice in a few years' time. And I know these have been some tough questions to answer. So Thomas, thanks so much for taking the time out and sharing your insights with us.
Yeah, that's a pleasure. And I'm hoping, as I mentioned, I can join you again in 6 or 12 months and we'll have even more to dig into.
I've just been speaking with Thomas Hughes, CEO of Appeals Center Europe. You'll find their first transparency report down in the episode description. And that's a wrap for this episode of the Social Media and Politics podcast. Thank you so much for tuning in. Next time, I'll be speaking with Drs. Louis Brumfield and Matthew Wall from Swansea University on gamified political forecasting. But until then, I'm your host, Michael Becerra, signing off from Alba. See you next time.